Good afternoon, folks. Welcome to today's Mailers Hub webinar, which we will be starting in 30 seconds to 60 seconds because we have folks still arriving here. So give us another minute, grab your last cup of coffee or whatever, and we'll start up here in just a few seconds. Thanks. Okay, good afternoon again. Welcome to today's webinar featuring reference speakers from Axiom talking about the California Consumer Privacy Act, CCPA. We'll be reviewing what's going on now and some of the things that lie on the horizon that really will make a difference to all of us. Just as a little bit of housekeeping, you can see that there is a copy of the slides, a handout that's available for downloading. You can see that up on your panel to the right. And if you have any questions to ask, please type them into the question box and we'll get those answered for you toward the end of the prepared remarks. As I said, today's presentation is being provided by our friends at Axiom, who are experts on the type of information you'll be hearing. So with that, what I'd like to do is turn it over to Mark Smith, who would, from Axiom, who will introduce his colleagues from the company and proceed from there. Mark?
Thank you, Leo. Yes, my name is Mark Smith. I'm actually the lead salesperson for Mailers Hub. Basically work with all of our data products and hygiene services. Also joining me from Axiom are John Monty and Laura Boone. They are subject matter experts for our data products as well as our hygiene services. Our goal today is to provide a refresher of CCPA, updates to CCPA. Important to remember, we are not lawyers, so don't hold anything that we say to the letter of the law. And the number one thing to remember with CCPA is that everyone needs to be in compliance with the regulations. So your mailers, how you handle customer inquiries, how we handle them, especially when it comes to the actual customer inquiries and authenticating individuals, also maintaining an opt-out list. Many of our large clients have actually hired attorneys to make sure they are in compliance, but it is up to all of us when we have any interactions with individuals that we are in compliance with the regulations. With that, I'm going to turn this over to John Monty to walk us through the presentation today. So take it away, John.
Thanks, Mark. And can everyone see the agenda screen? There might be a slight lag.
I can see it.
Okay, very good. So the things we're going to go through today, and we're going to go through most of this, and then we're going to have an opportunity for questions. So we will hopefully have time for that. We want to talk about what the California Consumer Privacy Act is, also known as CCPA, its impact to our businesses. There's some definitions and data categorization we're going to go over, consumer access, opt-out, and delete. We've added some May 2020 updates, so brand new updates, things that we're seeing on the horizon since we last did a seminar in January. So there's quite a bit to go over today. First, just a little bit about Axiom in terms of where we stand with this. We're well known in the industry for data ethics and data governance. It's something that Axiom has really staked its reputation on. First and foremost, we want to keep our business safe. We want to keep our clients safe. And those of you that are reselling, we want to keep your clients safe. Consumer transparency, notice and control is paramount and is Axiom. We're the first company in the world to create the role of Chief Privacy Officer. We do more than 500 privacy impact assessments, which basically reviews the viability and the legality of various data uses. We do several privacy and security audits. We do at least 30 of them per year. They're very comprehensive to make sure all data is being used properly. And we're leaders on global expertise and oversight. So we're working with many different organizations around the globe. Acxiom is a global company. Our largest amount of experience is in the United States, but we're in many countries around the globe. So CCPA, what is it? It is the California Consumer Privacy Act. It was passed in California by voters, actually by the legislature, in June of 2018, with an effective date of January 1, 2020. So that has now happened, and that is in effect at this current time. It impacts for-profit businesses that meet at least one of the following thresholds. Acxiom meets all three: at least 25 million in annual revenue, those that acquire information on at least 50,000 California consumers, or those that have at least 50% of their revenue derived from the sale of personal information. So we're actually, on all three of those measures, we have to be fully compliant with CCPA. What does CCPA enable consumers to do? It's really all about consumers and their ability to control data. They have a right now to be informed when they want about our data. They have a right of access to our data. They have a right to have data deleted. They have a right to opt out from marketing, and they have a right not to be discriminated against. I feel like that's always been in place, but that is reinforced with CCPA. It is about the consumer. It doesn't say specifically what businesses can and cannot collect. With some exceptions, it doesn't say what businesses can and cannot do with the data. What it does say is that if you're a business that collects data in California, as Acxiom does, you must provide the consumer, upon request, a report of the details of the types of data that you've collected, the categories of data that you've sold or disclosed to third parties, and the category of third parties with whom you sold or disclosed data. So we'll go into some examples of that. Consumers can also request to be opted out from selling or disclosing their data, and they can request that their data be deleted. Those are all important facets of CCPA. So the impact, it is again effective January 1st. Data for the prior 12-month period is really what that governs for any resident of California. So a consumer response is due within 45 days of a consumer request. When companies are not required to provide more than 2 reports within a 12-month period. Each business is responsible for their own readiness and compliance. That's important because Acxiom has spent a great deal of time and effort on how we're going to comply. We recommend that each individual entity work with their own legal and regulatory staff to figure out how they're going to interpret. There are some differences in terms of that interpretation. I would say in general, Acxiom has taken a very conservative approach because, again, protecting our business and our clients is paramount. And of course, there's always some exemptions and exceptions. I think that's probably true with almost any regulation these days. So know your partner's practices. We want to do a business verification. So we want company information verified. We want industry and self-regulatory memberships identified. The data collected is the identification of what is considered sensitive or restricted, the identification of data that is being collected and shared, and then our data hygiene and processing, so what we're doing to keep records up to date, and our contractual agreements with our sources. Things we're looking at include the point of origin review of the data, an opt-in notice. Is that required? Are consumers given an option to opt out when their data is used? Do they have notification? Do they have choice whether they want to have their data used or deleted? How the data is being used? What our privacy policy is for this particular country, and actually this is specific to the, California and the US, although Acxiom has been looking to adopt these rules for the United States as a whole because we believe that other states will copy what California has done in the months to come, in the years to come, so we want to be ready. And it is for both online and mobile use, direct and indirect collection of data. Some critical workflows for our readiness. These are things that have actually already happened. We've identified the different data that's been collected at the attribute level. We have identified our inventory of what we've sold and what we've disclosed. And really we're disclosing data by types of sources collected and by data category. So we've also categorized third parties to whom data was sold or disclosed. We now have a process in place for opt-out and deletion. So a consumer can come to us and say, you know, we no longer wish to have our data shared, or we wish to be deleted completely from your database. So the consumer has access to request our systems to validate their identity and to provide a consumer report. There are some definitions here. I'm not going to read all of these, but this will be available to you in the PDF that Miller's Hub is providing about personally identifiable information, what is considered anonymous and pseudo-anonymous, what is de-identified, what is considered aggregate information. So now the opt-out and delete, which are really important parts of CCPA. The opt-out, the consumer has requested that their information, no longer be sold. The data collection is still allowed for these customers, but we cannot sell. Axiom, if someone has requested that they opt out, we cannot sell the consumer's data. Also, third parties with whom the data was already shared have to be notified. And again, the consumer cannot be asked permission to resume sharing for another 12 months. There's also a deletion capacity in CCPA where the consumer has requested that the information be deleted. CCPA allows for the retention of a minimum amount of data to identify the consumer. We have to do that in order to make sure they stay deleted, and support the exempt processes such as completing transactions, deleting security incidences, debugging existing functionality, and certain types of research that are considered to be part of public interest. So those are some of the exceptions I talked about. To be kept, generally the use must be compatible with the consumer's understanding of the use of the data at the time of collected, or it has to be collected from a source other than the consumer. There are some gray areas with California Consumer Privacy Act, and the gray areas is the law is not that clear in our assessment on prohibiting the continued collection of new data about the same consumer. So that is an interesting point there. Once the consumer has said, okay, I wish to opt out or I wish to have my data deleted, well, what if 3 months later a source provides information on that exact same consumer, maybe a source we haven't worked with before? It's a bit of a gray area with CCPA legislation. Axiom considers a delete request to be a request to delete the existing data and discontinue collecting new data. So we've taken a very conservative approach there. We're trying to not collect any new data because that's really what the consumer's intent was. But the interpretation of that is not the same across all companies. So that's something where you would check with your own legal and regulatory advisors about how you're going to proceed once data has been deleted or opted out, and then it might become available from another source. Consumer access is another really important part of CCPA. We want to identify the data collected. We want to identify the data sold and disclosed by category. We want to identify the third parties to whom data was sold and disclosed. Process opt-out and deletions, and then consumer access requests to validate their identity and provide a consumer report. So some steps here in consumer access. There's a validation that we go through to make sure that John Monty, who's speaking to you, it really is my information. We do that. That consumer can make 2 requests in a 12-month period. It's portable, or it can be delivered. So it can be delivered online, or it can be delivered in the form of U.S. mail. There is a notice that has to be provided on a marketer's website for opt-out. We have 45 days to respond for consumer verification, and we provide access via a website and via an 800 number. So now we want to talk about what's new, and there's a lot that has gone on here. Some of this is forward-looking that we're going to talk about, where things are not concrete yet, but there's a lot going on in our new regulatory environment that we do want to discuss today. And at this point, I do want folks to be able to ask questions, because a lot of this is forward-looking, and we're in the same process or the same step that you all may be in, that we're just collecting this information. We're in the process of evaluating and figuring out, okay, how is Axiom going to be compliant with what is going forward from this point?
Hey, John, before we go into this, I have a couple of questions from the preceding portion. Can we give those now?
Yes, absolutely. Go ahead. We've got time for that.
The first one, I think it was on slide 10, I look back. You talked about the responsibility for partner practices. If you're a commercial mail producer, what is your responsibility regarding how the list provider or your client, which may have supplied or acquired a list, what they're doing? Could you clarify the responsibility for partner compliance in such situations where there are several people involved in producing a mail piece?
Yeah, I mean, whoever the entity is that is actually producing the mail piece is going to have to provide what the source is. So, if you're an entity and you acquire the data from Mailers Hub, for example, then your entity that's probably the source that you're responsible to report. If the inquiry comes into Mailers Hub's going to say in this particular example that they source the data from Axiom. So, I mean, because Axiom's client, and the example I'm trying to point out here, would be Mailers Hub. Mailers Hub's client might be an end user who's producing a content that might come from several sources. So,
and if I can add, Leo, if your commercial mail client, they're doing the printing and the mailing. The end user, whoever the customer is, basically when that mail piece goes out, it's got it, and there are two different things here. One's a customer mailing, right? So somebody mails to their customers. More than likely, that initial inquiry is going to come back to that customer. It probably will never get to the mail house because they're the ones responsible for responding to that customer. There's a difference if your client orders a prospect list. And this is where we see a lot of the interaction on our side. So they've rented a mailing list from Axiom. The piece goes out. The inquiry will go back to the person, the company that was doing the mailing. They say, well, where did you get my name from? They're supposed to authenticate, at that point when this person makes the inquiry, they're supposed to authenticate that person is who they say they are. The minimum they need to disclose is, they don't have to mention Axiom, but they say I bought it from either a mail house or I bought it from a compiler of consumer data. But you don't have to mention exactly who you got it from, where you got it from during those conversations. Now, sometimes, the end user may not know exactly, where the list came from, so they'll refer it to your mail house. Now, the mail house gets the inquiry. They have to go through the same similar steps. They need to authenticate that person. And then they're only required to disclose that they bought it from a consumer list compiler. It was sold, for their end user. And again, these are all of the things that the end user, the mailhouse, and Axiom, all of us have to be aware of the regulations and be in compliance with the new law. That's my short. It's a little confusing, but hopefully that made sense.
Well, I think that the critical question is, if you're the mail producer, are you responsible for whether your list supplier is in compliance with its responsibilities, or does each party have to just tend to their own knitting?
Well, no. If it's a customer list, that they're using for the mailing, the customer needs to make sure that their data collection practices and their compliance with the law is correct.
Okay.
That's right. So that, it's really, there isn't any responsibility on the mailhouse when you're talking about customer data. And it gets a little iffy when you're looking at prospect list information, because a lot of the times that it comes into, like, my client who was the broker who bought the list. They get an inquiry from a consumer about a mailing that they had a complaint, or their customer calls them and says, all right, what do we do next? So, it's that process that needs to be managed for a prospect list, but I don't personally see much issue or concern or activity with a customer list. That really rests upon the company, the end user.
Okay, because I think the concern for many of the people on the call today would be whether or not they have any upstream, exposure, liability, compliance requirements, and so forth, if they simply are supplied a list of whatever type and for use in preparing a mailing.
And if you are supplied a list, you would have to disclose upon a consumer inquiry what type of data, like it comes from a third-party compiler. As Mark said, you wouldn't have to state that the ultimate source was Axiom. You just, that it comes from a third-party compiler. Probably the two most important things that you do have to do as a mailer, though, is if the end consumer comes to you and says, I wish to opt out, you have to make that available. And if the end consumer says, I wish to have my information deleted, then that mailer is not going to be able to mail you again, because the consumers requested that, with some exceptions that we talked about, where it's like compliance or notices of late billing, where there's actually transactional data. There are some exceptions in place, but for pure prospect marketing, that deletion request has to be honored, and that opt-out request has to be honored.
Okay. All right, thank you. Okay, so that clears up what I had here for questions. So I think, John, at this point, you can go ahead and continue with what you had planned.
Yeah, those are great questions. So a little history. This was there was some, I'm not going to say wheeling and dealing, but there was some negotiation back and forth between the privacy groups in California and the California legislature. So the California legislature said, if we pass CCPA, are we good to go? Great. That got passed, and then it was passed in 2018. It became enforced January. Well, now California has requested, the Attorney General has requested updated deadline for additional regulations in California. That deadline is actually May 31. And we have some information about what's going on. Regardless of those updates, I should first say California begins enforcement of CCPA, what we've been talking about, on July 1st. So everyone's got to be ready to go as of July 1st if you're not already ready. But in addition to that, there's quite a bit going on with updated regulations, because there's a ballot initiative that is almost definitely going to be on the ballot in California in the fall. We don't know what exactly that's going to look like yet, because the final version has not been written. But it will be called CPRA, which I did not spell out on the slide, so I'll go through that. California Privacy Rights Act. It's actually different than CCPA. The California Privacy Rights Act, in all likelihood, will be on the ballot in California this fall. Likely it's going to be a mail-in election. We don't know that for sure, but it seems the indications are California will do almost an entirely mail-in type election this fall. There are already 1 million+ signatures gathered by the privacy organizations in California, so this is highly likely to move forward. And we can tell you some of the things that we think will be in that new legislation. It will require the establishment of sensitive personal information, such as whether it is financial information, whether it is health information, whether it is location-based data about where you are physically located. So that kind of goes a little bit further than what was included in CCPA. It will grant consumers the right to correct data that they say is incorrect. That is not part of the current CCPA environment. So that's an additional step that may become law. It will change the rules and fines for opt-in. It will have stronger governance on the sale of information about minors, in particular those aged 0 to 15. So any minor that is under the age of 16 is actually going to require a double opt-in. That is moving forward already, but that will be reinforced with, we believe, with the California Privacy Rights Act. And then lastly, there will be a new state agency in California that will be created called the California Consumer Protection Agency, also abbreviated CCPA, which this gets a little confusing. And that will be self-funded from fines that they impose upon businesses that are not in compliance. So there's a lot going on there. It is likely to be on the ballot, as I said, this fall. If it passes, and again, I can't predict whether it will pass or whether it will not pass. We don't know the implementation date yet. But to give you some frame of reference, CCPA was passed in 2018, and the implementation began January of 2020. It was about a year and a half later. Enforcement actually begins July 1st of 2020, almost 2 years after it was originally legislated. So there's going to be some ramp up time, we believe, between the passing of California Privacy Rights Act and when it will be enforced, but there's a lot of additional steps that I just mentioned, and I'm going to stop there to see if anyone has any questions.
Well, the question that came to my mind was when you mentioned the phrase self-funded through fines. That seems to suggest that they have a motive to be very attentive to offenses and aggressive in collecting the penalties that apply, which may make compliance by anybody any interested party very much more important than might be the case under CCPA.
I would agree with that. I think there's a little bit of an opinion there, but I share that opinion. I find it personally a little bit curious. Again, I'm not an attorney, but the agency that is going to be created to do the enforcement, we understand, will be funded by the fines that they issue. So yeah, there's definitely going to be some motivation for strict compliance there. Whether I can't predict, but I could see some legal challenges there to that kind of funding for that sort of agency. But again, it's hard to predict what future activity will be. We also haven't seen the final verbiage of the California Privacy Rights Act that will be on the ballot. It is not final yet. There's additional regulations due by May 31, which is in the future, only by a couple of weeks. And then there'll be some time for California to put that together. Probably later this summer, we'll get an idea of what that ballot initiative is going to look like.
Okay, so we don't know at this point whether the threshold for being subject to the CPRA would be different than that for CCPA.
We don't know that for sure yet. We're just starting to get some information as it's been shared. Correct.
Okay. Yeah, and part of what I've seen, Leo, is that the penalties will be even more severe if CPRA passes.
I would agree.
That's one part of it.
Well, the reason I'm asking is because, of course, you've got mailing companies in 49 other states who often don't appreciate their potential exposure to one state's rules. So that's why it might be very important for us to be able to make them aware of this, even though they may be in some place sitting in Delaware feeling they're beyond the reach of California.
Yeah, and again, for the mail houses, I think only when they get an inquiry from a consumer, that's the key. If for whatever reason somebody calls them, that they reply accordingly and adhere to the regulations. The other thing is if people request to opt out, I mean, ultimately it's on the end user to maintain an opt-out list. But I've got to assume that many of your commercial mail clients, they're doing NCOA, they're probably doing suppression, but the ultimate responsibility is on the on the end user to make sure that their data, their customer data, is up to date.
Now, of course, just to muddy the whole thing further, if you've got, because many companies now, many mailing companies want to offer value-added services that go beyond simply putting paper in an envelope. Some may be doing or providing list maintenance services. And at that point, I'm sure things get a little bit fuzzy because they would have taken on a certain level of responsibility for a client's list. And the question could come up whether that level of responsibility includes compliance with the CCPA issues.
Yeah, I think a little bit of a gray area, I think, in the interpretation of CCPA that we have seen. So that's a good point.
And it may, you know, because we haven't actually seen the enforcement yet, you know, that there, I think what it will ultimately come down to is due diligence, right? So if the client does maintain an opt-out list, and you can prove, hey, we took the customer list and we suppressed out the people that said we wanted to opt out, but one or two names were in there by accident because the suppression didn't work. At least you can show them that you've done your due diligence. It's way more about neglect or non-adherence to the regulations, where I think you'll see the actual enforcement.
And of course, is it your understanding that if CPRA passes, that it would supersede the CCPA, or would they somehow be mutual?
I think it's in addition. It's in addition to.
It would be in addition. In fact, my colleague Laura Boone just pointed out to me that I mentioned this, but it's worth mentioning again. Currently, CCPA has that opt-out and the request to have data deleted. It does not. CCPA does not require that consumers can have their information corrected. Our understanding is that California Privacy Rights Act, if passed, will have give consumers the right to have their information corrected. That is a big hurdle. That is going to involve some lead time for any data collector such as Axiom to be able to do that. In what categories we're going to have to do that is a little bit unclear, but that will all be future information that we learn.
Right, but in any case, if it does pass, it'll be another level of complication, not a replacement level of complication, it'd be a second level of complication.
Yes, complication, compliance, it becomes sort of the cost of doing business in this new environment, is what I would say.
Okay.
Any questions? I'm going to talk about what other states are doing in a second, but any more questions on what may be coming with California Privacy Rights Act?
No, not at this point, thanks.
Okay. What Axiom has done, anticipating that other states would have legislation similar to this, is that we're positioning ourselves so that we're able to do enforcement nationally. Thus far, our enforcement has really been narrowly focused on California, but in terms of our our in-house capabilities and operations, we're able to apply this to other data from other states as we will need to be able to do that. We anticipate that there will be what I would call copycat type legislation. There was quite a bit, there's at least a dozen states or so, and I think we talked about this in the last seminar, that had legislation in place. None of them had moved to the point of passing legislation yet. And then, in between then and now, a little something called COVID-19 happened, which has put this great big pause into everything, right? So there are a lot of legislatures, most that are not even in session at this point. They've been suspended due to COVID-19. Those that are in session or that are meeting remotely have been almost focused exclusively on public health, on the economy of their states, and on remedies and compliance, not compliance, but remedies and ways to combat COVID-19 and ways to reopen their economy, reopen their businesses. So that's kind of added a little bit of a pause. But we will see, as legislatures reopen, the reopening of, or the continued discussion of regulations that are similar to CCPA. I think that will be copied first. because what's included in California Privacy Rights Act hasn't really been established yet widely to all the other states, whereas CCPA is already in place in California. So I think we'll see that first. That doesn't mean every state will look exactly the same. And so when you're looking at this, I think it's going to become very important on individual marketers to be aware of what other states will be implementing and have the capabilities to be compliant. Any questions about that?
Now, I had a question that's basically, whether or not, Joe's Mailing Company in Topeka, Kansas, has any place to go to find out what's going on with other states. For some things, some issues, there are organizations or clearinghouses of sorts that offer advice or at least news about what's going on. But has the consumer rights or privacy protection arena come to a level of maturity yet where you have these resources developed?
I think we're starting to see that. In fact, I think we might have a website that we can make available that has some updates on what is happening. I'll see if I can make sure we make that available to everybody. That is a good point. That we're just sort of getting to that point. There's so much activity. It's like, well, where do you go to keep track of all of this? And I think I've seen, and I'll follow up on that, some websites that we can go to try to keep track.
And of course, is it fair to say that if, pick a state, Vermont, if they pass a privacy law, as California did, that there would be one level of understanding from what the plain language of the law says, but a second level that's probably harder for people to discern, that would be what the implementing regulations add?
I would say yes to that. And it's not necessarily going to be exactly the same as what California did. So,
okay.
At some point, potentially, where this logically goes, in my view, is that enough states pass legislation, then the federal, our federal Congress or federal legislature will have to take this up and try to nationalize this and pass at least some minimum floor or minimum level of consumer protection. There is already, I believe, a consumer financial agency, but our national legislature in Washington hasn't really taken this up. California's been out in front, but if enough states introduce copycat legislation, I think you'll eventually see this addressed at a national level.
Yeah, that was a question that we had here, is which states are the ones that are busy looking at this or actually have a likely measure ready to go. And then, in turn, as you just mentioned, at some point, would there be a federal imitation, whether it would be superseding the states or not?
I would. Go ahead, Mike. Think about what happened with the do not call files, right? When that all first started, states had their own do not call lists, and then there was a federal one, and now basically it's all FTC suppression files. So that went from individual states and then ultimately to a national opt-out file. That may or may not happen here. And I'll tell you what's happened for us in California as we prepare for this. There were two important pieces of the legislation. One, as a compiler of data, you can't have name and addresses you have to have people that are 18 years and older, right? So you can't really have any minors on your mailing list. So we had a couple of million records where we did not have known age. And we've kind of figured out a way to get most of that age on the file, but we're still dropping 2 or 3 million records in California that had always been on our file historically. But in order to make sure we're in compliance, we've dropped those records. The other is children's data. The new legislation requires that you have two sources of opt-in information for children. Number one, you cannot have any kind of a mail piece for a minor that's 15 years of age or less. That is a major violation. You can have names of children 16 and 17, but you've got to have the double opt-in in order to mail to them by name at the parent's address. So because of that, and because that information is so difficult to acquire, we've dropped most of the children's coverage in California. We have it for the rest of the country now. We're prepared to make changes if that is necessary. But we have basically set up our products as well as the data suppliers to make sure that we're all in compliance with the data that's collected, how it's used, how it's managed, et cetera. So there's a lot to this, and I think that would also impact any of the clients of your commercial mail houses that might have any children's data on their file. I'm sure there's some companies that very likely do. So that's just an important FYI to be aware of.
Of course, I think as we talked about earlier, it's ironic. You have to know who people are so you can not include them.
That's correct. Yep.
That step has
now,
been,
in that regard, somebody asked a question. What about like Highlights magazine, which people may buy for their grandchildren? I guess they can still be addressed to the grandchild, but now there's that individual, that minor.
Well, the subscriber has to be an adult. Obviously, the subscriber is purchasing the subscription for the minor child or the minor grandchild, and it is okay for example, for Axiom, it's our interpretation to know that a particular household has an interest in providing a children's publication, or that a particular household has the presence of children. But what we cannot do any specific marketing that by the child's name or by the child's age, or that is addressed directly to the child. That is prohibited unless there's this double opt-in, which is almost impossible to get. The other piece of this that Mark stated that I want to repeat because it's really a big barrier here is that you have to know that each person in your database is at least 18 years old. So there are still some of our records, it's only a minority at this point, where we don't have the date of birth or the age. And so if we don't know that they're 18 years or older, we can't comply with saying we know for sure that they're not a minor because we don't have that information. So we've had to go back as part of our compliance at Axiom to double down on getting the age and the date of birth so that everybody in California we can verify is at least 18 years of age. And we've added some sources for date of birth, and it's actually made us stronger in that regard with that information so that we can be compliant. But that's a pretty difficult step that a lot of marketers have struggled with.
But I think the question had to do with whether or not the existence of the grandchild on an address list was itself problematic. Even if the subscriber was not a minor, if you have an address file, which probably Highlights does, and probably most of it is people who are under 18, is that of itself a problem?
If they're only sending the subscription, to that child's name, I really don't see an issue with that because it's a customer, it's a relative that purchase, but they're just receiving. It's when you use that list for some other purpose. That's okay. Where, right. So
that the distinction then is whether you're using it for fulfillment of an order or to develop marketing leads.
Correct.
Okay. Thank you. That is a big difference.
Yeah, the Laura Boone household, just as an example, can request the purchase of Highlights magazine and can say, you know what, the reader is going to be Susie Boone, who might be 10 years old. That as a customer relationship, that fulfillment house can send highlights magazine addressed to Susie Boone. What that fulfillment house cannot do is now say, because we know you have a 10-year-old in your house, we want to sell you, we want to let you know about sale at the children's place. That is by our interpretation, that steps over what is now permissible. Can't do that.
Now, if you are a clever marketer and you have a list of individuals who are under 18 or 15 or whatever the age may be, and you keep this list to the side, can you incorporate those names into your prospect list, your marketing list, once you have information that the individuals on that list have exceeded the age of 15 or 18 or whatever? Is that a legitimate thing to do?
Well, again, at least in California, you could have the name of a 16 or 17-year-old if that is a double opt-in. So you've got to have you've got to have a mechanism to be able to show the state that you did it correctly. You cannot have the name of anybody 15 or less for marketing prospect purposes. A customer list is different, so it depends on how you use that. But in children, data has always been difficult to acquire because of the privacy and sensitivity issues. So we certainly don't have we don't know as much about the actual children that are in households as what we have on our file, because there's a lot of restrictions on how you compile it in all the other states. But California has made it virtually impossible to do that from a prospecting standpoint.
And this is Laura. I'll just chime in and clarify one point that even if we do get children's data with the double opt-in, we still at Axiom are not going to carry minor names on our prospect files. So we would only use that information to be able to populate into our data about a household, a presence of children or children's age range, but we would not carry those minor names.
Okay. Now, if you have, just to clarify this little thing, if you are if you're highlights or if you're whatever, and you send a promotional piece to an addressee in a household with minors, advertising a product for those minors, whether it's a publication or whatever, you're still safe because you're not marketing to the minors, you're marketing to an adult.
To the adult, that's permissible.
Okay. All right. So it's not the presence of people being in the household who are underage. It's the person to whom you send the marketing message.
Yeah. Correct. I mean, adults and parents and grandparents are obviously going to continue to buy and purchase goods and services for minors, and that's perfectly legitimate. But the marketing has to be done to the adult.
Okay, so even though kids can watch ads on Saturday morning cartoons, tell mommy to buy you this. Well, as far as mail ads go, you have to send a piece to mommy.
Yeah.
Well, and there, think about this, Leo. It's customer data is one thing, and prospect data is another. Now, certainly, we know in the nonprofit space, in the catalog space, there's a lot of exchanging that goes on. So you have to be very careful. It's one thing if you're mailing your own customers and using your own customer data. It's another if you're getting data from another cataloger or another nonprofit. You've got to make sure that data is in compliance because it's not your data.
Right.
You know what I'm saying? Yeah.
And maybe a couple of questions come along here. One is, probably the most obvious one is, all of this, the CCPA, CPRA, only affects printed ads, right? This does not affect people who are sending ads on the web, for example.
I think digital compliance is, go ahead.
It applies to any file. So that can be, I think John had a previous slide that talked about de-identified, just the different types of data. So it's really any file that you have. Yeah, any audience list, whatever, of consumers in California, in whatever entity that is.
Okay, so it's controlling the use of the list, not necessarily the medium through which the list is used.
Right,
It's
well,
the
and
maintenance of the list, really.
I'm sorry?
It's the maintenance of, like, what data is being kept and housed on a consumer in California.
Okay.
Right.
And to clarify one thing, does all of this conversation apply only to commercial mailing activity and not to nonprofit?
I don't think anybody's exempt.
I don't know of any exemptions either.
In California, we don't believe that there's an exemption there for nonprofits.
Okay, so just in case anybody was listening who thought that they didn't have to comply if they were a church, a school, a hospital, whatever, it applies to the list, as Laura said, not necessarily to the user of the list. Okay,
Correct.
Let me see if we see. I don't think we have any more questions. I would remind all of our attendees today that the slides are available to download, and if you have taken notes, you can supplement those with a copy of the slides. If you have any questions, of course, you can always send them in to us here at Mailers Hub. We can forward them back to our colleagues here at Axiom. But not seeing any more questions, I want to thank Mark and Laura and John for an outstanding presentation. My head hurts, but you did a good job. It hurts for a good reason. So we are definitely going to ask you folks to come back and teach us more later on in the fall if CPRA passes, because that's going to be one more thing for us to pay attention to. Again, thank you to the audience today for calling in and being very attentive. Thank you for your questions. Thank you, Michelle and Jennifer, for making sure the lights stay on here and that everything works. And again, thank you to Mark and his colleagues at Axiom, Laura and John, for a great presentation. If we don't have anything else here, I don't think we do. I hope to see you folks coming up soon for our next webinar on sales use taxes, another fun discussion. And we'll probably have our friends here from Axiom back in the fall, as I said. Until then, please stay safe. Keep yourselves masked and gloved and sanitized and so forth. And we'll talk to you again soon. Thanks. Bye-bye.
Thanks, everybody.